This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
Hello and welcome to the inSecurities podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments with a practitioner's perspective on the stories you should be following. As always, I'm Chris Ekimoff, and I'm here with my co-host, Kurt Wolf.
It is great to be with you again, Chris. We've got a really great episode lined up for today. We've invited a few friends to join us for what I hope will be a little bit more like a roundtable discussion. Usually it's a little more Q&A, but today I'm hoping we're going to have a nice open conversation. Chris, I was thinking about how to sort of set this one up, and so I'm going to try this on for size. Believe it or not, we are not the only podcast produced by PLI. There is, for example, a relatively new podcast called Fast Tracked, which focuses on emergent issues in the legal profession. And longtime listeners should be familiar with the Pursuing Justice, the Pro Bono Files, which is a PLI podcast that provides a behind-the-scenes exploration of pro bono and public interest legal work. Over the years, Chris, we've shared a couple Pursuing Justice episodes here in our feed. Listeners, you can scroll back to inSecurities episodes 12 and 40 to listen to the episodes that we found particularly interesting or helpful. I think, we've tried to focus a little bit on some of the things that we were talking about at the same time that they were covering it. Over on Pursuing Justice, well, what we've discovered is maybe there is more overlap than we realized as we've been on this journey. As I mentioned, we've got a few friends with us today, one of whom is Alicia Aiken, who is the host of Pursuing Justice. Of course, we want to get her voice in the conversation, but Chris, do you want to say a few words about Lish before we dive in?
I'd love to. And Kurt, great background on everything that PLI is offering in the audio space. I'd like to think that this might be the Voltron, right? We're bringing together multiple podcasts here to our listeners. And Lish, there's no one better to share that with. Lish has spent 25 years working with the public and nonprofit sector to advance social justice for people living in poverty and surviving violence, including 15 years as a practicing trial attorney at Legal Aid Chicago. Lish is currently the director of the Danu Center's Confidentiality Institute, a national policy and technical assistance project that supports helping professionals to protect privacy for violence survivors and crime victims. And she is a faculty fellow with PLI's Interactive Learning Center. And as you mentioned, Kurt, since 2019, she has been the host of PLI's podcast, Pursuing Justice, the Pro Bono Files, our sister podcast here at PLI, which gives a behind-the-scenes exploration of pro bono and public interest legal work. Lish, thanks so much for joining us on this crossover episode of inSecurities and Pursuing Justice.
I'm so excited. I really am. I mean, I will admit that I have some sibling rivalry with
Excellent.
you all.
Competition breeds excellence, right? Somewhere in there.
Exactly. Yeah. Exactly. The other thing that makes this so much fun is that, so when we talk about what we're trying to do at Pursuing Justice, we really are trying to expand people's imaginations about what pro bono can look like, what it can be, what you can do. And when we imagine who we're talking to, I kid you not, from day one, we've been calling that person the securities lawyer who thinks they have nothing to give to pro bono.
Are you pointing fingers at Kurt or? Oh, generally. Got it. Okay. Sure.
I do feel like there's a spotlight on me all of a sudden, but carry on.
So to get to be here in a space where securities lawyers talk to each other is pretty exciting. And so we've been around since 2019 and it is all over the map. I mean, we highlighted pro bono where folks are doing exactly their expertise, but in a pro bono space, like the corporate insurance attorney who negotiated an emergency insurance contract for the donated plane, sitting on the tarmac full of it was just right up his alley and it was super easy for him to do. And he did it pro bono. And then it runs the other gamut where we've featured, the in-house counsel at Amazon staffing a legal clinic for homeless families in a shelter that's actually in the first floor of Amazon's Seattle headquarters and kind of everything in between. So That's what we're doing. And I'm pretty exciting today to get to talk about where there really is some crossover with securities expertise and possibilities for pro bono.
Yeah, I mean, you're absolutely right, Lish. It's not necessarily an area where you would expect there to be a ton of pro bono work or pro bono opportunities. And I'll just tell you during my career, I've spoken with securities practitioners, usually folks that are doing like more regulatory work, not the enforcement folks like me, but they'll look and they'll say like, I'm not a litigator. What am I going to do? I don't know how to do pro bono work sort of with my area of expertise. What crossover is there? And you're right. We have found an area where there are lawyers and law students who are out there doing securities pro bono work. And that's what we want to talk about today. So in addition to Lish, we have two fantastic guests joining us here in the virtual recording studio. Sorry, listeners, it's taken a little while to bring their voices into the conversation, but we wanted to set this thing up. We have Nicole Iannarone, who is an associate professor of law at Drexel University's Thomas R. Kline School of Law, and Christine Lazaro, who is the vice dean for academic affairs and a professor of clinical legal education, and importantly, a director of the Securities Arbitration Clinic at St. John's University School of Law. Since we've got a couple more guests, I don't want to spend a ton of time doing bios, but why don't you just tell us a little bit about yourselves and your experience? And Nicole, why don't we start with you?
First off, thanks so much for spending time on this issue. It's a delight to be here and to get to chat with you. I am a professor who focuses on some securities law. And before my current role, I started a law school clinic where students get to represent regular investors who have a dispute with their stockbroker in arbitration. So that clinic operated for about 6 years. Now I'm at Drexel, and I spend my time researching and writing about regular investors who have small securities claims. I've also spent a little bit of time serving on a committee at FINRA, the National Arbitration and Mediation Committee, and just concluded a term as chair. And that committee is where we give advice to FINRA about how its rules in its mandatory arbitration forum are working and whether we need to make any changes.
Christine, tell us a little bit about yourself.
Sure. And I just want to join Nicole in thanking you for inviting us and for focusing on these issues. So I'm at St. John's. I've been there for 17 years, first as a supervising attorney with the clinic, and then as its director. We'll talk a little bit more about what the clinic does, so I won't go into that now. But in addition to the clinic, I also teach courses on securities and broker-dealer regulation and business a little bit more generally. And I also serve on FINRA's Investor Issues Committee, which is an advisory committee to the board that looks at a number of different issues and rule proposals that go to the FINRA board and provide input from the investor perspective, and also on the SEC's Investor Advisory Committee, which similarly looks at issues from the perspective of investor protection. So thanks again for having us.
This is really exciting. I'm very much looking forward to this conversation and talking about the clinic, Christine, your clinic at St. John's, and then also learning more about, Nicole, the clinic that you ran at Georgia State. But before we zoom in on that work and the need for the clinics, I want us to set a baseline because this is a crossover episode. So I don't know what we're talking about very well. I spent my career doing eviction and family law and privacy law. So for the listeners out there who are like me, I want to set a baseline. Tell us about the FINRA arbitration process. What avenue does FINRA arbitration provide for retail investors to pursue claims about broker-dealers? And don't forget to tell us what the heck FINRA is.
So let me start with this. FINRA is the Financial Industry Regulatory Authority. It's a self-regulatory organization that anyone who wants to buy or sell securities on their behalf or on the behalf of others must be a member of. So I think for lawyers who aren't in this space, the best analogy is to think about a mandatory state bar. You must be a member of the bar in order to practice in a number of states. Same thing for FINRA. To be a stockbroker, you need to be a member of FINRA. Arbitration has been a feature of securities laws for a very long time, really since securities came to this country. Way back in the day, it served, well, it still serves, a legitimizing purpose. There were some contracts, legal contracts, that were just not enforceable at law. They used to be called time contracts. We call them options today. So if you want somebody to invest in one of those, well, they need to have a means to recover if something goes wrong. Why am I going to give my money to somebody if I don't have a legal mechanism for enforcing it? So that's the long history of arbitration in securities. Today, nearly every investor who has a dispute with a stockbroker is forced to arbitrate it. It's in the customer account brokerage opening documents. And it's often a surprise to the clients that Christine and I have worked with that, in essence, it seems like the fox is guarding the hen house. You mean that this self-regulatory organization forces me to bring any claim I have if something goes wrong in an arbitration forum that it oversees? The answer is yes. So I can go a bit further into the ways that arbitration works based on claim size if you guys would like, or we can leave it there and get further into the discussion.
I'd like to toss it over to Christine. Talk a little bit about what a typical claim would be. Let's imagine you're talking to a forensic accountant who's not as knowledgeable about the investor arbitration process at FINRA. Hypothetically speaking, what is that typical claim that you all deal with?
So most of the claims we're handling involve investment advice that doesn't line up with the investor's goals and objectives. And so, for example, the broker may have recommended that the investor invest in a risky product, but the investor is conservative. Or frequent trading strategy when the investor should have been buy and hold. Sometimes the advice is negligent, and it really is just either the broker didn't fully understand the product, or the investor, or didn't really understand the strategy, or didn't explain to the client how they were prioritizing one of the client's objectives over another. So, for example, focused on income and chose an investment product that would give the client the income they needed, but would sacrifice the principal. And so the client's losing money on the investment, but they're getting the income, but they really didn't understand that trade-off. And the broker didn't adequately explain that decision was being made to the client. Sometimes there actually is fraud, and the conduct is much more intentionally bad. And sometimes the broker is actually stealing money from the client. Sometimes it has to do with the broker prioritizing their own interests over the client's interests. So choosing the investment products that are going to pay the broker the most money, that are going to be the most remunerative for the broker, but probably not in the best interest of the client. Or a frequency of trading that's going to make the broker the most money, but ultimately make it very difficult for the client to be profitable in the trading.
And Christine, you're talking a lot about kind of the decisions made by the investment professional here. But Kurt, I know in past episodes, we've talked a lot about, I guess I wouldn't say decisions made by the investment professional, but how technology plays into maybe some of these issues, right? Mm. There are algorithms and investment strategies that sometimes remove the personal decision-making out of that. Are we seeing, Christine, some of that in the claims that we've been dealing with recently as well?
So we're getting a lot more phone calls from investors who are trading on their own on online platforms. And so they're not dealing with a broker. They're not getting their investment advice from an investment professional. They're not speaking to a human being. And the issues, they're seeing a whole different category of issues. So sometimes it's they thought they were doing one thing, they were doing something else. And so they really didn't understand what buttons they were pressing when they were placing the trade. Sometimes they didn't fully understand how trading actually works, or that there could be delays in the trade getting executed. So they think they're placing a trade at the price they see, and by the time the trade actually gets executed, it's getting executed at a very different price. They may not fully understand how margin calls work, and that securities in their account may get liquidated to meet that margin call. And then we're seeing straight up hacking cases where their account's been taken over and then been drained because either the security protocols weren't in effect or weren't working well, or the firm didn't pick up on red flags, such as account access from a different country or another state, or a change in address immediately before a significant withdrawal in the account, things along those lines. And so we definitely are seeing a lot more of those types of complaints and concerns from investors.
So, I mean, I think what I hear you both saying, Christine and Nicole, is that there are investors out there that are experiencing some problem. They have some complaint about their broker dealer, whether they're talking to an individual who maybe is making a recommendation, or whether they've had some trouble using, an online platform or an application that they downloaded on their iPhone, but somehow something from the investor's perspective has gone wrong. And a way to address that is through FINRA arbitration, or as you say, Nicole, maybe the only way for these folks to address it is through FINRA arbitration. I can imagine, for a sort of mom and pop investor who just opens, an online account, that can be daunting or maybe seem like an impossible task. And so I think maybe that's where arbitration clinics come into the picture. But I mean, tell me a little bit more about what you see as the role of arbitration clinics. Who are their clients, and why exactly might those clients need help from a clinic? And I'll just sort of open the floor to both of you, because I suspect you have different, probably complementary, but maybe different perspectives.
The role of arbitration clinics is to provide access to counsel for those investors whose claim is too small for a private attorney to take. Now, Christine and I have both been working in this area for a long time. And during the time we've been working in it, we've always thought it's nearly impossible for an investor to get an attorney if they haven't lost at least $100,000. And that's a pretty significant amount. That would make a huge dent in my life if I lost that much. Now, while we thought this anecdotally and based on our experience, I've spent a little time diving into arbitration awards, and I can tell you that there is a relationship between whether someone is represented or not. And that relationship is driven by how much money they've lost. Nearly all investors with claims over $100,000 have a lawyer. At that $100,000 mark and below, not as much. It dips down to about a 50-50 representation rate. The clients that arbitration clinics serve are regular people who have followed the advice that they're given. I need to save money for my retirement. And to do that, I should really work with a professional. I might be great in my business, but that doesn't mean that I know how to invest and ensure that I've got a nest egg for the future. The clients I've worked with are welders, mail carriers, hairdressers, librarians. They need the money that they lost to support their life. Just because they had money in the first place, money to invest, doesn't mean that they had the money to go out, pay a lawyer to represent them against a large financial institution. Our clients would tell us stories, and I know Christine has some of these as well, of if I don't recover this money, I have to make a choice of whether I pay my medication or mortgage this month. One client told us that without the money, they were choosing between dog food and toilet paper. So it makes a difference whether these investors have access to get back the money that they've lost.
And sometimes the claim isn't actually about having lost money. Sometimes the client lost access to the money because they were put in a liquid investment. And in that case, it's going to be virtually impossible to get a lawyer to take the case because there aren't actually damages. And really what we're doing is we're helping the client communicate with the firm, get access to their money back. And we play a number of different roles. We also provide a screening function. So sometimes our role isn't actually to bring a claim, but to explain to our client what happened and why what happened may have actually been entirely proper. And like you said, sometimes the problem is they don't understand what has happened. So it's not that something went wrong, they just don't understand what happened. And so, for example, we've had cases where a client has taken money out of their account over time, but didn't track of it and didn't realize how much money they had taken out of the account, and then thought their account had declined significantly when in fact that money was actually in their bank account and the broker hadn't done anything improper. So we were able to actually spend the time, go through all the documents and explain to the client where all of the money was, trace everything, and give our client peace of mind. Nothing had gone wrong. The broker hadn't done anything improper, and everything was as it should be. And they could continue working with the broker. They can continue on with their lives knowing that they actually had the money. And in addition to representing clients, the clinics also do work beyond representation. So we play an important role in the regulatory space to give voice to the smaller investors. And so commenting on pending regulation, how is a change to the arbitration rule going to impact a small investor or somebody who may have to go through that process per se? And so the clinic will file comment letters on regulations and rules, and we've commented on rules proposed by FINRA, by the SEC, by the Department of Labor, by state securities regulators. And we take the opportunity to really give perspective and voice to how regulations, how things that may be trying to be done to protect small investors might have unintended side effects, and make sure that's being considered and accounted for. And then finally, we also engage in investor education efforts. So we do a lot of outreach to libraries, senior centers, CFW posts, high schools. We've started doing investor education outreach to law school students who aren't already in the clinic, and making sure that investors can become better informed to hopefully not have these issues in the first place.
It is so interesting listening to the two of you talk, because the way you describe what you're doing is frankly the way that legal services describes its work, right? And I'll be honest, when we first had a discussion about this crossover idea, I was like, investors equals money. What are we doing? This is a pro bono podcast. But, pretty quickly I came to, by, listening to both of you and doing a little bit of research, to understand first that we're on the brink of, a full generation of people whose entire retirement is in the stock market, in a 401k that they are expected to navigate themselves. And I say 401k or 403b, shout out to my nonprofit colleagues and brethren. And so, there are vulnerable people like you described, people who have worked their whole lives. And I hear you describing, exactly the way we talk about employment law and legal services. Like, sure, if you were discriminated against, you can sue and you can get attorney's fees, but the amount you earned was so low that no private attorney would ever touch this. So I love the way that you talk about your work as filling an access to justice gap for people who are relying on not huge investments to sustain their lives and their retirement, and for whom losing the money or not understanding what's happening is a huge deal. I guess I'm curious, do you think there's a space for pro bono attorneys to do this kind of work? Or are there structural reasons why it's not a good fit for pro bono, making clinics like yours even more important to filling the access to justice gap?
Absolutely. There are some issues, structural ones, that make pro bono difficult in this area. If we think about lawyers practicing securities law at larger firms, those firms have institutional clients, and investors tend to be bringing claims in FINRA arbitration against those very clients that larger firms represent in the securities realm. So conflicts present an enormous issue for bringing folks in to serve in these pro bono cases. In addition, this is a nationwide issue. If I think about where all of us are sitting right now and where we work, I think we're all in pretty large cities, mostly in the Northeast. That's where the clinics are currently located. They serve many folks. There are a lot of states where there aren't large firms, where they don't have lawyers who are licensed to practice in those states. So in addition to conflicts, the nationwide scope of the problem presents some unlicensed practice issues or multi-jurisdictional practice issues that structurally make this arena a little bit more challenging for pro bono attorneys.
Christine, I don't know if you wanted to jump in there. I'll pause just in case.
The only thing I'll say is sometimes the procedural rules in arbitration can be not intuitive for attorneys. And so there is a benefit to the client to have an attorney representing them in the forum who is familiar with the rules of the forum and the arbitration process more generally.
Yeah, I agree with Christine on that point. And there's been research that shows that there's informational asymmetries that are eliminated when an investor has an experienced attorney in the Securities Arbitration Forum. For those who specialize in this work, they're much more likely to recover against repeat player broker-dealer firms and their experienced counsel. So it's important to have somebody who knows the area a bit. And if folks are interested in doing pro bono, I think I can speak for Christine on this. We're happy to talk to them a little bit about it. But I think that repeat players on the claimant side are really important as well.
Yeah, I would agree with that because I do some FINRA arbitrations and it is a fairly specialized practice, right? I find that, when juniors are joining the firm and if I'm working on a FINRA arbitration and they raise their hand and they want to jump on, it doesn't look like civil litigation. It doesn't look like the federal rules of civil procedure that they learned, probably as a 1L a few years ago or whatever, if they've clerked what they've been watching in the courtroom for years. And so there is a kind of a steep curve as you figure it out. And I mean, Nicole, your point is absolutely right. A lot of these large firms, have outside counsel that maybe this is what they sort of do. Like they manage large firms, FINRA arbitration dockets, and they know all the procedural rules, all the little tricks and tactics you can use within the bounds of those rules to gain some kind of tactical advantage. And if you've never done this before, I think it's difficult. And so, let's sort of circling back to the question that you raised. I mean, I guess I could imagine a world where sure, pro bono lawyers can do this, but maybe it's like that needs to be what they do, right? And that's why we have the clinics, because I don't think you could just pick up one of these cases alongside, the like eviction or employment law case that you're used to doing. But maybe that's a separate conversation about like structurally, how are organizations that provide pro bono or legal services built? How are they funded?
Sure. I mean, and I'll just say, there's plenty of wonky regulatory weirdness in evictions, and I promise you, but you have expertise inside legal services to lead pro bono lawyers, right? To create materials, to do the training. And I think what I'm hearing is that the expertise certainly doesn't exist in legal aid on FINRA arbitration and small investor needs. And that where it really lies is in the clinics that Nicole and Christine are running. And so you would need somebody who is deeply knowledgeable and amazing, like Nicole and Christine, leading the pro bono, and they have full-time jobs doing policy education and leading clinics and working for the law school.
I guess coming into this area a little bit unknowledgeable about the services as well as the clinics themselves, what kind of numbers are we thinking for clinics like this across the country? Christine and Nicole, you guys are here, so I imagine there's two of you in every city and every state, right, across the U.S. Talk to us a bit about maybe the uphill battle that clinics serving certain areas. Liz, you talked a little bit earlier about the kind of jurisdictional issues with practicing in separate states, but where do we see that number of clinics and how is it trending based on the needs in the environment?
presently operating right now, there are 10 clinics in the entire country, and 5 of them are in New York. Outside of New York, there is a clinic in Chicago, a clinic in Pittsburgh, 1 in New Jersey, 1 in DC, 1 in Miami. So that leaves an entire
3/4 of the country. Everything left
Nothing.
of Pittsburgh or Chicago, right?
Nothing west of the Mississippi. Yeah.
Reminds me of that New Yorker
That's
map.
right.
And that includes some very large areas with aging population and really significant need for investor representation.
So we're at 10. Is that a growth number, or are we declining towards 10 and God forbid less at this point?
I think this is the lowest. At its height, there were as many as 24 clinics operating at one point across the country, as far west as California, and then sprinkled across the country and up and down the East Coast.
The difficulty, I think, the number keeps shrinking because there's a need for sustained funding for clinics. I currently don't work in a clinic right now, and I'm sad that the clinic I started closed. Ensuring that there's a source of clinics to support clinics going forward is really important. Now, this is true for all legal services. Christine and I can't sit here and say that of all of the pressing legal needs out there, that this is the most important. What we can say is that it's very important. And we can say that it is underserved. Again, just because people have money doesn't mean that they can afford to lose it. And to Licia's point about legal services, frankly, most of the clients that Christine and I have served and think about have too much money to qualify for legal services, even assuming there's capacity in legal services corporations to take on these types of claims. So the number, I think, keeps shrinking because we don't have enough funding to keep the clinics going and ensuring that experienced folks are able to lead them.
So, Nicole, wave your magic wand. How do we solve the funding problem?
Congress passed some legislation. One of the most interesting type of clinical programs that's been supported by Congress is in the tax arena. Lish, I'm sure you're familiar with low-income taxpayer clinics. They have exploded across the country since Congress stepped in and said, hey, IRS, we're going to give you some money. And from a state nationwide funding proposition, it's not a lot of money to help fill this need and ensure that there are lawyers there to help out in the tax arena. There has been introduced in the past, an Investor Justice Act that would give the SEC capacity and funding to provide for clinics in what Christine and I think are pretty much every state. Overall, it's a big amount of money for me. It's not a big amount of money for Congress. And there are other groups who could also jump in and provide some funding for it. I'd love to see FINRA bring back a grant program that they had many years ago that helped establish a number of clinics across the country. So basically working with those financial organizations that understand the need to provide sustaining funding, not just startup funding, would really help a lot.
I have often been known to complain that foundations are constantly funding startup programs that can be replicated, and they never fund anybody to replicate a program.
You know, Chris, I seem to remember Ann Kelly coming on the show and mentioning something about an SEC fund at Treasury that has, I don't know, a few $100 million lying around that nobody can tap. So while, Nicole, you are not the first person to come on this podcast and ask for Congress to pass some legislation, it may be simpler than you think, because I have a sneaky suspicion that the funds are actually already there. We just need to free them up. But maybe you're already working on that. I don't know. Anyway, so look, at the risk of, I don't want to muddy the waters, right? But I do want to try to sort of clarify kind of the scope of what the clinics do and who they can help. We've been talking an awful lot about broker-dealers and about FINRA arbitration, right? And certainly a ton of retail investors out there, they do a broker-dealer, or they do use one of these, online platforms or apps, use financial services professionals that are not registered broker-dealers, right? They are a registered investment advisor or some other kind of wealth management professional, and therefore don't fall within or under the FINRA umbrella, right? And so for them, FINRA arbitration it's just not a possibility. And so, what I'm wondering is, are there services available to these folks, clinics or some kind of pro bono services? What do I do if I've spoken to an investment advisor and I'm upset, I lost my money, or I don't like the advice that I got? What recourse would I have?
So I'm going to give you the lawyer answer. It depends.
Fair.
So like you said, FINRA arbitration really is only available for the FINRA registered firms and brokers. The dispute is with a registered investment advisor. To a large extent, it depends on two things. One, is that investment advisor duly registered with a brokerage firm? If so, FINRA arbitration may actually be available as a forum. If they're not registered, then it depends on what the contract says. So dispute may be subject to arbitration. If it's subject to arbitration, it should be subject to arbitration pretty much in any arbitration forum. So oftentimes, the most common forums used are AAA and JAMS, but it could be a small local arbitration forum that's close to the investment advisor. One of the important things about the difference between investment advisor contracts and brokerage firm contracts, FINRA has put into place a number of rules that govern what firms can do in their dispute resolution clauses. So they can't set venue at a place that would be inconvenient for the customer. It's going to be where the customer lives. And they can't limit the claims. There's a number of things firms are not allowed to do. Those limitations don't apply to investment advisors. And so if there is an arbitration clause, it may be with a forum that is inconvenient. It may be at a forum that has opaque rules, that is not transparent, that is incredibly expensive to access. And sometimes those claims just go to court because there actually isn't a dispute resolution clause. If it's not a registered investment advisor, then it gets even more muddied. If it's an insurance broker giving you advice, it's likely the claim would end up in court. If it's an online crypto firm, you might not actually be able to find the company to even sue. And so it does get a bit more difficult, one, to figure out who you're suing, and then to figure out where they can be sued, and then to determine what the cost of suing them might be if you are going to go forward.
So, Nicole, given what Christine's describing about how those investors might be impacted, do you see any way to fold addressing those investors' needs in with the advocacy work you're doing with FINRA, state legislatures, and on the Hill?
Absolutely. Arbitration does have a bad rap, but overall, FINRA arbitration has some features that Christine talked about that make it really much better than other types of arbitration. It's much more accessible, less expensive, and assuming you've got counsel, it's a pretty easy to use option to get recovery. So I know the SEC and the Office of the Investor Advocate is looking into what happens when you work with somebody who's not part of FINRA arbitration. Can we build capacity within the FINRA forum to take on these other claims? Can we go back to the early days of this country and force investment advisors to come into arbitration if the customer wants arbitration, and arbitration at an accessible forum like FINRA? So I started out talking about how arbitration came to this country with unenforceable contracts. It was always the consumer's option to bring somebody into arbitration in the event something went wrong. These types of solutions are being talked about: investor choice, expanding FINRA arbitration, expanding arbitration for registered investment advisors. So absolutely, there's a way to fold it into advocacy work. And I hope we have the ability to expand investors' ability to meaningfully get redress. It's a real social problem when we have bad behavior that can't be effectively litigated and enforced. It maybe could even give an incentive for somebody to, why not do something a little on the edge if we know that no one's going to be able to enforce against us?
And I want to just add, like one of the complications, we were talking earlier about the expertise needed to get in to handle a case in FINRA arbitration. And this is one of the challenges for clinics. We're typically handling cases that are in FINRA arbitration because we have that expertise. It is incredibly difficult for us to handle cases across all of these different forums and to get our students up to speed to handle cases across all of these different forums. And so in order to address the representation gap that exists, and that is even larger when we're talking about non-FINRA investment advice givers, it really is important that there be some consistency in the dispute resolution mechanisms that are available to investors who have issues when they're investing. Because from the investor's perspective, they just know they've given their money to somebody they see as an investment professional. They don't actually differentiate. Well, they're regulated by all of these different regulators and systems and subject to different rules, and that if they have a complaint with their crypto broker who might be registered with the CFTC, that's different than their registered investment advisor, who's different than their broker, who's different than their insurance broker.
I was going to say, I literally just had a moment of being like, wait, where is my financial planner registered? I'm going to be doing some looking when we get off this discussion.
We came really close, Chris, like so close to wading into an old Reg BI policy debate about, the duty of care that you might owe depending on what hat you're wearing and whether any retail investor actually knows, cares, understands. But we're not going to do it. Chris's eyes will glaze over. He's heard enough Reg BI on this podcast over the years. I do want to touch on one more topic that we've literally skipped over, and it has to do with outcomes. Nicole, a couple of minutes ago, you talked about arbitration as a way for investors to get recovery in appropriate circumstances. And I guess I'm wondering, what are typical outcomes in these arbitrations? And if does it matter whether you're represented or not? Are you more likely to get a favorable outcome if, one of your students takes the case on versus someone trying to go it alone?
So, yes, I love to think that lawyers make a difference, right? And one of the things that I studied is FINRA arbitration awards. FINRA publishes every decision of a panel that decides a customer's case. So I can tell you about the 15 or 20% of cases that go all the way through to an arbitrator's decision. But before I do that, I want to tell a little bit of a story that I think emphasizes why counsel is so important in these cases. I stumbled across two claims that sound really familiar. There's a Florida woman who had recently lost her husband and her mother. Husband had handled most of the finances and she needed some help. So she went to a stockbroker and ended up in a non-traded REIT that had some pretty high fees associated with it and that locked her money up, even though she had liquidity needs. On the other side of the country in California, a senior investor working with a different broker-dealer ended up in a very similar non-traded REIT, also high fees. Also, he needed liquidity, but it wasn't within that product. When both of them went to access their funds, they realized they couldn't get into it. Now, the Florida woman has been made whole. She was able to get back her money and use it. California man, on the other hand, in his 70s, is continuing to work as a security guard. The difference between their claims, I think, has a little bit to do with geography, and it's that geography that Christine told us about. Where is there a clinic? There's no law school clinic in California anymore. There is in Florida. The University of Miami's clinic help the Florida woman. Now, stories like that, some would say, well, this is just anecdotal. So looking at the actual numbers in FINRA arbitration awards from 2015 to 2019, I stopped because the pandemic changed things up a little bit. I can tell you that law school clinics have the highest recovery rates in simplified, the small claims. Law school clinics recover in over 56% of the claims that are decided by an arbitrator. Non-clinic attorneys recover in about 38%. They get $1 or more. If you represent yourself in these simplified claims, the recovery rate is less than 25%. I've found that there is a relationship between whether you have an attorney and whether you ultimately prevail in arbitration. Lawyers mean you're more likely to win.
I guess along those veins, Christine, Nicole, are there kind of those memorable or meaningful stories that have come from the cases that you all have worked on? I'm not looking for names and dates, but more some of those fact patterns, Nicole, like you just shared with some of those results, some of the work that your clinics have really pushed forward for those individuals.
So I'll tell one short story. We had a client who was an elderly woman who regularly dealt with the broker who sat in her local bank branch. So she'd go into the bank to do her banking and she'd talk to the broker who was super friendly, very helpful. He'd even take care of handling her deposits for her with the teller. Well, it turns out he was actually stealing money. And when he did give her investment advice, he ended up putting her into a complex variable annuity that paid him an incredibly substantial commission and made it virtually impossible for her to get access to her money unless she paid a really substantial surrender charge. And so we handled her case. We made a complaint on her behalf. And it turns out the regulators were also taking a look at the firm. So both the state attorney general and FINRA were looking. And interestingly, this was a case where we didn't actually have to even file the arbitration claim. And this is very common for us. We will often reach out to the firms pre-filing. We've done all of the work. We let them preview the claim. We're ready to file. These are the issues. Let us know if you'd like to resolve this. And roughly 70 to 80% of the time, we're able to resolve the case before we even get to arbitration. So that, I think, makes the numbers Nicole was just talking about even more significant, because those are the rates of the cases we actually file. We've actually helped about 70% of our clients by getting them money back or addressing their issues without even getting to that point, without even having to file. And in this case, we were able to get our client all of their money back. And not just, I think an important piece of this is not just getting her money back. That was a small part of it. The bigger piece of it was the betrayal and the psychological impact of having been betrayed in the way she was by this person she trusted so much that she had seen weekly in person and that she had come to rely on. And so this went a long way to dealing with those psychological impacts as well.
Yeah, echoing Christine's point, when I worked in the clinic, of all of our cases, only 2 of them went to award, and we won both of those cases, recovered for investors. Most of them are resolved just because clinics have a reputation with broker-dealers that they're not going to take a case if there's nothing there. And if they've done the work and set out a statement of claim and are ready to go, we'd prefer not to get anybody involved in a formal process and try and resolve it. For memorable and impactful cases, I've got 2 really quick ones. One is actually happened more than once, the investors who wrote thank you notes to the clinic when we told them they didn't have a claim. We took the time to explain why, and the thank you notes that we got said essentially, no one has listened to me before and explained what happened. The need to screen cases to provide investors an unbiased description of what's going on is really meaningful to investors. For a second memorable case, we had also a variable annuity Christine had that said on its face, don't sell this to someone over the age of, I think it was 65. And it was on its face unsuitable. The investment was sold to someone who was over the age of 70 and really needed our help to unwind and get back the money that they needed. The surrender fees were enormous, and frankly, the investment was clearly unsuitable.
Nicole, when you were talking about the success rate that you have in the clinic and how you can settle things, it reminds me of what we used to say in legal aid, which is never mess with a free lawyer, because there is no limit to the amount of time I will put into this.
The students are incredible. They get so invested in working for their clients. They're learning something they haven't done before. And yeah, I can't underscore how hard they work, how incredible they are, and frankly, how many of them join the clinic thinking, clinic isn't for me. I'm not into social justice. But after being in the clinic, they really understand why everyone should have a lawyer to help them, and that there are lots of avenues of providing pro bono and other help no matter what your expertise or background is.
And that's what's so exciting about this. And just so everyone knows, we're working with Nicole and Christine to get some law students on tape so we can do a deeper dive episode with them on pursuing justice to talk about their experience. And I just love the way this is literally doing the thing I talked about, like finding those law students who might have a career interest in securities and establishing early on that there is a place for them in pro bono and that they can make a difference, and that they may think they're about money, but they're actually kind of about social justice too.
Nicole and Christine, I'm going to put you on the spot with a question, just sort of off the cuff here. But, we do actually have a lot of securities law practitioners who listen to this podcast. If someone out there wanted to do this kind of work, they wanted to help you on your mission, they wanted to volunteer at a clinic, anything along those lines, what advice would you have for them? Who should they call? Where should they look?
I'll volunteer myself. Feel free to give me a call if you want to volunteer with a clinic. Send me an email. I will help connect you to a clinic. I know clinics also bring in folks, even if they've got a conflict of interest, they'll still come and talk to law students about their practice and help educate them. And we don't have to worry about the conflict if they're not representing clients directly. So there's education roles. And I'll also give a shout out to some work that Christine has done. She's put together a really wonderful set of materials on how to bring a FINRA arbitration through a number of CLE trainings that I'm pretty sure are web archived and that Christine can direct them to.
Christine, what advice would you offer?
So very similar to Nicole, absolutely can contact me. I think it's helpful to get an understanding of the FINRA arbitration process. Another avenue I will suggest that I think is sometimes overlooked, become a FINRA arbitrator. We need good people actually on the other side of this hearing these cases too. And the funny thing is that you might not think of that as pro bono work. FINRA arbitrators are not paid a whole lot of money. So that is actually a public service as well. And that really is so important. It's another important piece of this whole process to make sure we really do have great people considering these cases once they get to that stage.
I think this is really a great nexus of a lot of the things we cover both on the Pursuing Justice and the inSecurities podcast. Kurt, you talked about how are we going to merge these two things together. I spent a good 11 minutes watching the 100 greatest crossovers of all time, both in soccer or football to the international fans and in basketball. So I look at this pairing as kind of the Lionel Messi ball on a string or the Allen Iverson ankle breaking crossover of the PLI podcasting family. So we will definitely put a link in the show notes for our episode here to the great work that Christine and Nicole have talked about, as well as the Pursuing Justice Pro Bono Files podcast that Lish hosts, and there will be a future episode that features a lot of the folks doing the good work that we've talked about today. I just came back from a conference focused on fraud issues, and the discussion around the intersection between an aging population and the reliance on technology of that population that maybe isn't fit for their skill set or familiarity. My grandmother still is having trouble texting, right? I think that leads to a lot of some of the issues we've talked about, and I think that's only going to grow. So my hope is that when we revisit this topic in a few episodes or in a few months, there's maybe 11 clinics at that point. No pressure, Nicole and Christine. I mean, New York is a great place for that 11th clinic, but maybe we should look somewhere out west to do that. Thank you guys so much for helping support this episode and sharing this message. And for those of you listeners interested, please reach out to our guests today, as well as listen for that episode coming up on Pursuing Justice.
Thank you.
Yeah, I was going to say, of course, Lish, thank you for joining us. That really makes this thing work. Looking forward to your episode coming out, in a couple months, I think. And yeah, I'll just echo Chris, Nicole, Christine, thank you so much for coming on the show.
Thank you so much.
Thank you all so much for bringing attention to this issue. It's a really important one, and we're so grateful to be able to be here and shed some light on it.
Thanks for joining us for this episode of the inSecurities podcast. And a special thanks to our guests, Alicia Aiken of PLI's Pursuing Justice podcast, Nicole Iannarone of Drexel University, and Christine Lazaro of St. John's University. We always love to hear from you, our listeners. Look for us on social media to share your thoughts and comments or topics you'd like for us to explore on future episodes of inSecurities. Please use the hashtag inSecuritiesPod on X or LinkedIn to join the conversation. You can find me at EcomoffCPA.
And I'm at enforce_update.
Don't forget to subscribe, rate, and review the inSecurities podcast wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to inSecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, inSecurities can help you make sense of it all. A special thanks goes to the producer of inSecurities, Daniel Peinitz, as well as hosts Chris Eckimoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the securities sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.